Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and it shall be heard.
Good morning. Please be seated. Good morning, everybody. Today is a very special day at the 4th Department, as the Honorable Lynn Wessel Kane, who was appointed by Governor Kathy Hochul to our court on December 22nd, 2023, is sitting on the Appellate Division bench for the first time. We are joined today by Justice Kane's husband, Mike Kane, and her mother, Joyce Wessel, and her children, Michael, Jack, Matthew, and Grace, are attending virtually, and I guarantee they are bursting with pride right now. Also joining us today is Holly Park, who is Justice Kane's secretary, and her confidential law clerk, Dennis Glasscott. Justice Kane graduated magna cum laude from Boston College and from SUNY Buffalo Law School, cum laude. Her legal career began as an Erie County Assistant District Attorney under the then District Attorney, Kevin M. Dillon. In 2000, she left the District Attorney's office and worked as a solo practitioner, representing defendants in criminal matters throughout Western New York. She did that until 2009. At that time, she became the confidential law clerk to Erie County Family Court Judge Lisa Block Rodwin, who has since retired. She also was elected in 2011 and again in 2015 to serve as the Orchard Park Town Justice. In 2017, Justice Kane was elected to the Supreme Court 8th Judicial District. Initially, she was assigned to the expedited matrimonial part for 2 years, and then to a general civil trial part in both Chautauqua and Erie counties. Justice Kane is a member of the Erie County Bar Association, the New York Women's Bar Association, the Association of Justices of the Supreme Court of the State of New York, and has served as both treasurer and vice president of the Supreme Court Association 8th Judicial District. She has also been serving as a member of the Committee on Character and Fitness for the 8th Judicial District. Justice Kane is very busy and has been involved in numerous community activities as a soccer coach, Girls on the Run coach, youth court advisor, Meals on Wheels driver, and many parent-teacher organizations and clubs. Justice Kane, there are many 4th Department staff members present in this courtroom today who I can guarantee will be soliciting you to join their activities, especially your soccer skills. It is also important to note that once upon a time, Richard and Kate Kane had 16, that's right, 16 children. One of the children was named after his father, and young Richard married Mary. They had a family, including a son named Michael, who married Lynn Wessel. Obviously, young Lynn Wessel Kane was thrown into a family situation which necessitated that she quickly learn how to get along with and integrate into a very large, diverse group. Those skills will prove to be a huge asset on the Appellate Division for our new colleague, Justice Lynn Kane. We are thrilled that Justice Kane is joining us on the Appellate Division and are confident that she will be a wonderful addition to the court. From all of us at the Appellate Division, 4th Department, welcome. Now we're going to clear out this courtroom and get to work.
Oh, nice. Many of these folks will be the staff here in Rochester. I realize 10:15.
Okay, our first case for oral argument this morning is number 19, People versus Matthew Boza. Boza. How do you pronounce it so I get it right?
Mr. Bauza.
Okay.
Good morning, Your Honors. Congratulations, Justice Kane. There's two things that control the outcome of this ineffective assistance of counsel claim. That's the Supreme Court's findings of fact in this case, and this Court's decision in People v. Hunt from 2000. I'll start with Supreme Court's findings of fact because they're straightforward. Supreme Court found that this attorney, the defense attorney, failed to cooperate or even engage with the prosecutor's attempt to schedule grand jury testimony, and said that it was due to that sudden and unexplained cessation of communication that Mr. Bowser was denied the opportunity to testify in front of the grand jury. Obviously, Supreme Court didn't use the terms unprofessional error, but I think these findings of fact do establish unprofessional error in this case. And People v. Hunt is a case that is incredibly difficult to distinguish from the facts at hand, and I think it's telling that the people in their respondent's brief declined to even cite or discuss Hunt. There's three elements, three ingredients that I think make Hunt really on point with this case. Those are an unprofessional error resulting in the defendant not testifying in front of the grand jury, an attempt by the defendant to remove counsel and get new counsel, dissatisfaction with that counsel, as well as the counsel's own motion to be relieved of the assignment. And the third ingredient is that the plea is counseled by the same attorney or the same office as in Hunt, who failed to facilitate the grand jury testimony.
So, counsel, let's have a little chat. All right, I'm going to agree with a lot of what you said, okay? But then I'm just going to ask you a couple questions. In the end, yeah, this particular defendant decided not to fire his counsel, isn't that right?
He was unable to afford counsel. What was put on the record is that his family was trying to hire assigned counsel, and the Supreme Court denied his assigned counsel's motion to withdraw. So he found himself...
Until new counsel was in place, right?
That's right, and because Mr. Bowser was unable to afford private counsel, he ended up being stuck with this attorney.
Okay, so let's go to the next step. Let's say that everything you say is true, which I'm not disagreeing with, okay? The next step would be prejudice, wouldn't it? What prejudice did this have to the outcome of this case?
So I think it's important...
On this record, okay.
So on this record, the prejudice is that he's counseled by the same attorney at the guilty plea.
So, but I guess I was searching in this record to find out, exactly what he would have told the grand jury that would have made a difference here, okay?
So that is not in the record. I would concede, of course, there is no record basis to point to exactly what that prejudice would have been. But of course, for this court in Hunt, there was no problem finding that it is prejudice to go into a guilty plea counseled by the same attorney who has been ineffective before. And I would also note that the Court of Appeals decisions in Wiggins and Hogan, which discussed the lack of prejudice, those are trial cases. One was a bench trial, one was a jury trial. And in those circumstances, in at least one of them, I believe in Hogan, the defendant did testify and didn't get an acquittal at trial. So it was easy to say that, your testimony would not have changed the result at the grand jury.
So
What about Simmons and Hernandez? Simmons, Court of Appeals, 2008. Hogan was after Hunt also, it was 2016, and then Hernandez, our court, 2021. They're all requiring prejudice.
And I think that's difficult to reconcile with Hunt. And I would note that Hunt postdates the Court of Appeals decision in Wiggins, which was 1996, which was the first time the Court of Appeals said that in this type of ineffective assistance of counsel claim, you need prejudice, unlike any other type of ineffective assistance of counsel claim in New York. So Hunt postdates Simmons, and I would agree that there are decisions from this court after Hunt looking for prejudice. But I think that there's a unique set of circumstances here where it's the same attorney, where there's the request to remove the attorney. That makes this case a lot like Hunt, and that is lacking in other cases from this court.
If your client has prejudice or has an argument as to prejudice, what would prevent him from bringing that in a 440 motion?
That certainly could be raised in a 440 motion. It's being raised on this direct appeal, but it could, to establish.
Could make a record on a 440 motion.
You certainly could, but I think that, Hunt was a direct appeal as well. And I would simply point this court to the similarities and the really difficulty of distinguishing this case from Hunt's facts.
Thank you.
Thank you.
Morning, may it please the court, Amy Wallensack on behalf of the people, and congratulations, Justice Keene. As Justice Bannister mentioned, that in order to find that counsel was ineffective here for failing to effectuate defendant's appearance before the grand jury, there would need to be some indication on this record that there was prejudice to defendant. He has never given any indication what he would have testified to in the grand jury. There was no affidavit in counsel's motion in the lower court indicating what that testimony would have been. As Justice Noack pointed out, it would be more appropriate to develop a record on a 440 motion. And also in terms of prejudice, counsel obtained an extremely favorable guilty plea for defendant where he received 6 years imprisonment when he could have been sentenced to up to 42 years based upon the multiple sales involved in this matter. And unless the court has any further questions, I'll rely on my papers.
Just real briefly, I look for prejudice separate and apart from there would have been an alternative result. There would have been a different result. I couldn't find any. It always seems that that's the prejudice. That's the only prejudice cited in the case law. Have you come across anything else?
When I looked into it, the cases that I found and cited to in my brief all say or would have obtained a different result had he testified. So I read that to say it's almost as like further expanding upon how you would demonstrate that prejudice.
So it's sort of open-ended.
I would agree, yes.
Okay.
Thank you.
Thank you.
21, People versus Michael Smith. We just have to wait. Mr. Keem's coming up, okay? Good morning, Mr. Keem. You unmute yourself, please. Unmute yourself. Thank you.
Sorry about that. Good morning. May it please the court, Brad Keem for Mr. Smith, the appellant. In this case, we assert the detail and volume of the uncharged crimes and incidents committed by the trial court were overwhelming and deprived the appellant of a fair trial. For example, testimony about how AJ and the appellant met, that was proper, the progression of their relationship, that it included sexual intercourse. But what was not okay is the trial court permitting AJ to testify about the initial sexual encounter where she was bleeding, the volume of incidents in a Burger King parking lot, in a bathroom, digital and fist penetration. I mean, the volume of these incidents were overwhelming when this went down to a 2-count indictment. None of these incidents had, I can't say anything to do with the crimes charged, but were so prejudicial that they deprived the appellant of a fair trial. Limiting instruction was not enough. This is the kind of evidence that Molyneux was designed to prevent. I'd also add that the court cannot consider the people's Weinstein argument. Consent was not argued below. Unless there are questions about that issue or the sentence or any of the other issues we raised, then we'll rely on our brief.
Mr. Keem, real quick, I appreciate the fact that the Molyneux decision that the court issued left the door pretty open as far as the allegations of the uncharged crimes. And these are all the crimes that were alleged to have occurred after the victim reached the age of 18. But it seemed to me in reading the trial transcript, a lot of it didn't come out anyway. There was a little bit about the drinking of the cloudy liquid and then being dizzy and passing out. But again, the court was careful to sort of restrict that testimony only to that and not as to some of the more significant allegations that were ultimately dismissed after the indictment. Would you disagree with that, or do you think that the record still came through?
I think it's two things I would push back on. Is I would say that the record still came through, and I would disagree. There's fist penetration that the jury was allowed to hear about. That had nothing to do with the two allegations that were remaining after the district attorney's office, failed in their grand jury presentment on several, this was what, a 25 count indictment at first or even more.
The context of that was about, trying to prepare her to have a baby. There was a lot of testimony about that, and that kind of went to the nature of the relationship, didn't it?
And I think that you can say the nature of the relationship is enough, that you have a person that their relationship, not get too far into the record based on how interesting, the words are hard to find when it comes to this case. But I think because I'm tiptoeing so much around some of this stuff is because it is so prejudicial, and the nature of the relationship, the preparing for childbirth stuff, it's just not relevant. How it explains the nature of the relationship is highly questionable and unduly prejudicial in our view.
Thank you.
Good morning, may it please the court. Excuse me, Chris Eagleston, in response for the people. Congratulations. I think Mr. Keem's argument is well made today. He expressed his discomfort with even saying certain words or describing certain facts, and I think that that's sort of the crux of the issue. But this Molyneux case goes back to the Victorian era. In Victorian era America, the courts of this state said the jury can hear this kind of stuff when it's relevant, when it's important. In this case, it was. And the court did exactly what they were supposed to do, balance the probative with the undue prejudice
And
carefully.
that's what we have to decide if they did that.
Understood, Your Honor. I do understand that, but I would like to say that I was simply trying to get to her written decision. In this case, her written decision, I think, is fully and fairly dispositive of the issue, and had I not been compelled to write way too many words, I could have just said what the judge said below, because she has the relevant cases, she has the relevant law, and she described her balancing. And I think that really does get us all the way through this analysis. But even if it didn't, the issue here is to be considered. There were, I forget now, either 6 or 7 unrequested limiting instructions given. They were unrequested, they were unobjected to, they didn't ask for anything more, they didn't make any complaints of it in a motion for a mistrial on any of these limiting instructions.
What about the rape, the forcible rape at age 15? That wasn't one of the dismissed charges, those were all later, but there was a lot of graphic detail as far as that was concerned. What's the relevance of that?
In that case, as the trial court wrote below, it was relevant to the element of forcible compulsion. We're talking about a child of that age at that time, a charge we couldn't bring, by the way, because it was in a different county. Statute of limitations hadn't run, but it was not relevant to us. But it was relevant to this case because this was an instance of forcible compulsion, and that she had attempted in the past to overcome that force and knew the futility of it. In these kinds of cases, we're often concerned about what a jury is going to think when they're charged with determining whether or not there was forcible compulsion, and their instinct is to say, I would have fought harder than that. What happened the last time does become relevant.
But we have 3 years go by. We have the forcible compulsion at age 15. We have 3 years going by where they have an ongoing relationship. And there's really not mention of any forcible compulsion until after he gets out of jail in 2017, or I think maybe even 2018. So what about that? I mean, the jury's not hearing about all that. They're hearing about the force at age 15, and then we're pretty quickly getting into the charge in 2018.
Well, the jury could have heard about what happened in those interceding years, I suppose, through defense counsel had they elicited the testimony. But I would note that this corroborated, and corroboration is always important when we're dealing with cases where we're relying chiefly on the victim's testimony. It really goes back to corroboration. In this instance, there were controlled texts there at the end, and when she made accusations about what had happened, it was discovered that he had changed materially since his incarceration. I believe in his words, jail broke me, right? I believe that's what he said.
Maybe
I think it was
ruined.
relevant to that, Your Honor.
Maybe ruined me.
Ruined, there you go. Is there any more questions?
Thank you.
Thank you.
22, People versus Royal. Oh, and Justice Kane is recused on this matter. And you're solo.
Oh, I thought they were appearing through video. No?
Oh,
I don't think so.
no, you're right. You're right. I'm sorry. You're absolutely right. Sorry, Ms. Seeley, I almost like just knocked you off. Okay. Go ahead.
Good morning, Your Honors. May it please the Court, Carrie Connor on behalf of the appellant Siobhan Royal. Today I'll be focusing on point 1 of my brief. The Court did not conduct a sufficient inquiry into Mr. Royal's alleged refusal to attend his sentencing hearing. When Mr. Royal denied on the record at his Outley hearing that he refused to attend his sentencing, the Court did not ask him any follow-up questions. Instead, they immediately suggested calling the holding center deputy on the phone and allowing him to testify telephonically. When defense counsel objected to the deputy's absence, the Court assumed that Mr. Royal was just trying to delay court. This was the Court's subjective interpretation of Mr. Royal's conduct, which denies the defendant due process. The Court also relied on the prosecutor's unsupported assertions when making their decision to enhance Mr. Royal's sentence.
Counselor?
Yes.
Didn't the judge give the defendant an opportunity to take the stand and explain what happened that day?
That's correct, and Mr. Royal did not testify,
Yeah.
but it is the Court's responsibility to conduct the sufficient inquiry under Outley.
But the court took the testimony from the deputy who explained what happened that morning under oath.
Correct, they did.
And we also had the logbook as well.
You're right. So the people called the deputy up on the phone, and he testified over the phone rather than in person.
So what else should the court have done?
I think the Court could have asked follow-up questions regarding the circumstances surrounding
To
Mr.
who?
Royal's.
To who?
To Mr. Royal after he denied, as soon as he
Mr.
said.
Royal, he didn't want to take the stand.
Right. So Mr. Royal said, I did not refuse to attend my sentencing hearing.
I think we have your argument.
Okay. Just one more thing. Since Mr. Royal did not have the autonomy to transport himself to court, this non-appearance should have been subject to greater scrutiny. Since his location was known and he was across the street at the holding center and present the next day. Okay. If there are no further questions, I'll rest my
Thank
brief.
you. Stay. Okay, Ms. Seeley?
Good morning, Your Honor. May it please the Court. I'm Harmony Healy on behalf of the people. I think that the court did validly give a precondition that he voluntarily appear for his sentencing conditions. He did violate it, and the sentencing court did properly enhance the sentence. They made a sufficient inquiry. They did a summary hearing by calling the deputy and also admitting the logbook into evidence. Defendant had an opportunity to testify. Defendant had an opportunity to cross-examine the deputy and ask further questions, and he chose not to do so. And so therefore, I think that it was properly enhanced.
Thank you.
Thank you.
Number 24, in the matter of Angelina M.
Good morning. May it please the Court. Thomas Babylon on behalf of Appellate Maryland. The most important thing for this Court to understand is that as soon as any disclosure was made by this child, the mother prevented any access of that person to the child.
Well, which person? Just one of the persons?
Well, there was no disclosure with regards to the other person. So, and I'll get to that, Your Honor, but with regards to the uncle, there was a disclosure made that the uncle had inappropriately touched the child on her leg, over her clothing, and that she had taken a video of that and showed it to her mother. Now, the mother initially did not know whether or not to believe the child because the child had been lying a lot recently and misbehaving. So what she did, she approached the uncle immediately. She told the uncle that he was not permitted to come to the home, and the evidence is clear that the uncle was never permitted in the home or around the child again. That's not contradicted in the record. Additionally, she spoke with Angelina because she was concerned that she may not have been truthful about this and asked her what she wanted done. What did you want done about this? She didn't say that she wanted anything else done with it, so she left it at that. With regards to the grandfather, there was never any disclosure with regards to the allegations concerning the grandfather until after the investigation began. So with regards to that, and the court even, I would say, conceded this when they didn't make a finding that she should have known or should have known about this conduct because there was no such finding made by the court. Instead, what the court did with regard to the grandfather, they created this new allegation that mom had abdicated her parental responsibilities by initially denying that the conduct had occurred. No one had disclosed this to the mother prior. The father had raised her and several other siblings. There had never been any allegations concerning the father. So when she was immediately confronted with this, she was surprised. She said, no, that's not possible. She must be lying. Okay? Immediately, or shortly thereafter, within 5 days, the department recontacted my client. My client said, I'm sorry, I apologize, and she thereafter cooperated with the department. So there was, the court created this, the court conformed the pleadings to the proof to the petition without any notice to my client, which was in violation of her statutory rights under 1051 of the Family Court Act.
What about the allegations in the record that Angelina was cutting herself and displaying stress type of symptoms, and no help was forthcoming by the mother for these kind of issues?
And I'm glad that you mentioned that. So what the court failed to ignore, what the court ignored in this particular case was that Angelina had run away from her mother's home. The mother filed a police report as a missing person, and she was discovered to be living with her father. She was living with her father for the entirety of the summer and had only moved back into the mother's home a few weeks prior to these allegations becoming known. What my client explained to the department was that she had tried to get her into counseling, had discussed counseling with the father previously, and that there was insurance issues. Now, the department, the AFC had to write a letter to the court because the department failed to get this child into counseling more than 2 months after they had taken supervision of her. So I feel it's kind of contrary to find the mother neglect for not getting her counseling in 2 weeks when the department failed to do that for 2 months. Additionally, with regards to the allegations to the grandfather, I apologize. I'm going to move on. With regards to the allegations, the neglect with regards to the boys, there was no allegation in the petition regarding direct neglect of the boys. It was derivative neglect based on the allegations concerning Angelina that the boys were also derivatively neglected. The court seemed to make a finding of direct neglect concerning the boys, which was not contained in the petition. They said specifically that the boys had been neglected because of the mother had accused Angelina of lying in front of them, and because she initially discounted the allegations against the grandfather in front of him. Now this was again, the court here had moved to conform the pleadings to the proof without notice to my client in violation of 1051 of the Family Court.
We already have that.
All right. Are there any other questions? Or?
I didn't mean to cut you off.
I don't know if am I done? I mean,
No,
is my time up or?
I just asked you not to repeat, so. Yeah.
Oh, okay. So, and with regard to the other point I want to discuss with regards to ineffective assistance of counsel, the attorney for the child. In this particular case, the attorney for the child recognized that there was a conflict. He had not contacted his client before the first day of trial. On the second day of trial, he had contacted his client, and he had been advocating for the exact opposite of what his client was requesting. His client was requesting return to the mother. In this particular case, he asked the court, please relieve me. I can't in good faith, present my client's case because I've been presenting the case the other way. And what the court did, the court directed him to substitute judgment for his client, without any evidence that a substitution of judgment was proper in this particular case. And I would argue that that issue was preserved by the AFC's own request to be relieved from representation of his client. Thank you.
Good morning, Your Honors. Walter Burkhardt, attorney for the children, Angelo and Kamani.
How old are the children right now?
Well, at the time, they were 11 and 15 at the time.
No, but no.
And so what does it make them? This is a couple years ago, right? Or?
Right, exactly. So 13, 17.
Okay.
So, Your Honors, when we're talking about neglect, we're talking about an objective standard, a reasonable and prudent parent standard. And with respect to the fact when Angelina disclosed about the sexual abuse of Uncle Gregory and Mom eventually came around to believing it, that she was touched inappropriately, there are a number of actions she could have taken as a reasonable and prudent parent. The first thing you'd think she'd do is she'd provide support and comfort and love and outrage at her brother for what he did to her daughter. Furthermore, you think she'd seek counseling. She'd call the police. She'd get CPS involved. But she did none of those. Instead, she simply said, okay, we have a mess. What are you, as a child, going to do about it? And of course, as a reasonable and prudent child, she didn't know what to think of it because the mother's supposed to be the parent.
We understand that.
Okay. Then moving on to
Counselor, what's your position with regard to your clients, your boy?
Right. So the reason I was getting into this is because then when we get into the second incident when
What is your position?
My position clearly is there's derivative neglect with respect to Angelo and Kamani. I mean, it's clear of the case that that there's an intimate relationship between the neglect of Angelina and Kamani and Angelo. I mean, she basically got my clients involved in trying to corroborate her position to the police. She basically called them a liar, or called Angelina a liar in front of her brothers, and her brothers for a while didn't even want to see Angelina. In addition to that, when we're dealing with derivative neglect, clearly her actions were so unconscionable with respect to Angelina that she really wasn't safe to be around any child whatsoever. I mean, for example...
We don't need the example, I think we understand that.
Okay. The one other thing that I'll just briefly discuss then has to do with the effective assistance of counsel. And I know the appellant's counsel dealt with more the effective assistance of counsel with respect to the attorney for Angelina. But with respect to the counsel that was appointed on behalf of Angelo and Kamani, I mean, he throughout the whole proceedings zealously advocated on behalf of his client's positions. I mean, they wished to stay with the mother, and he maintained that and made sure that they did stay with the mother. At the same time, he could not ignore the fact that there was this neglect going on, and there had to be precautions in place to make sure, and safeguards to make sure that they are safe while in the care of the mother.
I think we understand.
Thank you for your time, Your Honors.
Good morning, Andrew Greenberg, attorney for the child, Angelina. I think in a nutshell, the evidence presented here was that the mother failed to take any acts that would result in any healing for the child. In the entire record, they point to one suggestion of one thing that the mother did, excluding the uncle from the home. And although there is evidence to support that she did, what there is not evidence in terms of even that one isolated fact is when she did it, how she did it, in fact, whether she took actions promptly upon disclosures by my client to her. She refused to testify. She could have elucidated the court if there was information there to provide.
So that was an important thing you said, she refused to testify.
Yes.
She refused to testify about any of the things that happened, and so we can take a very adverse look at that refusal.
Yes, as the family court judge did herself, that's correct. And that's impactful both in terms of the mother, I mean, throughout the case, you can see that. We could have an explanation in terms of actions that she took to help Angela heal. Nothing.
Okay, let's ask you this, how is she doing right now?
She seems to be doing better than she was at the time. That's what I would say. She has gone through a lot as a young child, as the record reflects, but I think it seems to me, this is the best period of her life in terms of what we've seen in the record.
And she's with her father right now? No.
With her, it's her stepfather.
Stepfather.
Yes,
Okay.
the father of her two siblings. Just quickly, one last thing, which is on this ineffective, I'm sorry, Judge Nowak, did you have a question?
I did. It might be
Go ahead.
separate from your point, but the family court made some comments throughout the record.
Yeah.
Calling the mother a gem, and that was probably the most mild one. Other statements about the family and certainly seemed callous, if not worse than callous.
Yeah.
How should we regard those comments made by the family court?
Yeah, I too read the record that the family court judge was not at all happy with the mother. That seems pretty darn clear. That's not the question. The question is whether it results in some type of legal bias. The claim here is that it results in legal bias and should have precluded the family court judge from taking a negative inference. Now, there was no request for the judge to recuse herself. So I think that takes care of that issue. But even more importantly, I think, in terms of kind of the justice of the case, is that there's no allegation that bias was coming from anywhere outside of the case. The bias, as termed by appellant here, the concern that the judge had was coming from within the case. You know, you can see there had been not only the allegations in the petition, but that there was this whole pretrial proceeding that involved these text messages during the course of the proceeding from the mother to this vulnerable child, putting the entire weight of the proceeding and I would suggest the sake of the family, the mother's mental health, all on this child and trying to pressure her during the course of the proceeding to retract her statements regarding the family members. I think that was very hard for the judge to get over.
Thank you.
Thank you.
Thank you.
25 in the matter of Zachary S.
Good morning, if it pleases the court, Rebecca
Oh,
Cons.
wait, just one minute, we have to.
Oh, sorry, I forgot she's on.
Great. Okay, go ahead.
Good morning, Rebecca Cons for the appellant. Welcome, Judge Keene. I want to focus on point one, that the family court didn't find by a preponderance of the evidence, or the DSS didn't show by preponderance of the evidence that the mother violated the suspended judgment. There was no willful violation. The missed visits were due to reasons. The Christmas visit, she was vomiting, and she contacted the foster mother and had a discussion whether it wasn't appropriate to have the visit.
Well, counsel, you know, you mentioned contact, and I think that's something that I noticed here is you know, there wasn't always contact between the mother and the people arranging these visits, which probably caused them to not be too happy with the situation. And I mean, we all have our phones almost glued to our hand. I'm sure she's like the rest of us.
There was some discussion that she had issues with her phone plan, that there was a lapse in coverage. I agree that there were times when she contacted the wrong party to make these decisions, but there was communication and there were reasons. She did provide the documentation about, she ended up going to the hospital for the vomiting following Christmas, so there was documentation provided. Our argument is that it was a month. Like, there was no leeway. It was during COVID. There were, you know, a lot was going on during that time with illnesses and trying to be extra careful. In total, they missed about 4 visits because of exposures of the kids and her. With the visit following Christmas was also canceled because she had taken the COVID test at the hospital and she hadn't gotten the results. Another big issue is the transportation issues. She didn't have a vehicle, and for the New Year's visit, she was supposed to schedule this transportation, and she was unable to in time. She finally got a code from, there was no Uber or Lyft or taxis in Penn Yan, and she had to go as far as Geneva to finally get a taxi service. DSS canceled the visit at 2:30. She finally got a code at 4, but by then it was too late. So she was making attempts. She was trying. And then there were issues with illnesses and transportation issues.
With respect to the health issues, she ultimately found she had a perforated ulcer.
Perforated ulcer, yeah. So it wasn't a big deal. This wasn't her just, you know, deciding that she wasn't going to attend. She's been referred to specialists, and she does have a perforated ulcer. As far as making progress, she's attending her drug counseling services, the FLA, CRA, I don't know if you call it FLACRA or not. They did testify that they had no issues. Appointments had to be rescheduled because of work schedules and transportation issues, but they testified that they had no issues with her and her attendance. As far as Her parenting, there was testimony from the kinship counselor that her parenting was improving, that they were seeing progress with her parenting skills. The kids were being more receptive, they were being more affectionate towards the mother. And in general, it wasn't in the best interest of the children to have her parental rights terminated. It's a very final act, and doing so a month after the suspended judgment seems like it's premature. She was taking steps to address the issues.
Thank you.
And if there are no further questions, I'll rest on our brief.
Thank you.
Good morning, Your Honors. May it please the Court. Ruth Chafee for the Yates County Department of Social Services. Your Honors, I think the issues that this court has to decide is whether there was evidence in the record at the trial level as to whether or not the respondent willfully violated the terms and conditions of the suspended judgment. As the court would note, the suspended judgment was very lengthy and had very specific terms in it in an effort to give this mother a chance to be reunited with her children in quick order, given the length of time they had been in foster care at the time the suspended judgment was issued. It had been 3 years at that point. As outlined in...
So now it's almost 5 years?
Yes, Judge.
Same family?
Yes, Judge.
And there are a lot, I'm sure one of your arguments would be, yeah, there were some excuses for some of these things, but this was a continuous problem.
Correct. That's correct. And, you know, the missed Christmas visitation and the New Year's visitation that were specifically set out, it's noted in the record that those were important to both the respondent and the children, given they were the first holiday visitation she was going to have had with the children in a long time, unsupervised at her own residence, and those visitations were canceled.
Okay, I think we understand all that.
And Your Honor, I would just point out that, as I did in our brief, that the department is not bound by an amount of time in which a violation needs to be filed. She was given a chance, and very early on was violating the terms and conditions of the suspended judgment. By the time this hearing was completed in July of 2023, she had missed several visitations following what was alleged in the violation petitions. It was really just a continuation of poor judgment and bad decisions on the part of the mother.
Thank you.
Thank you.
Ms. Gray?
Thank you. May it please the court. I've represented Zachary and Daniel from the beginning of the family court proceeding. So I'm very familiar with the excuses that have been proffered by the mother for her failure to comply with the terms of the suspended judgment. And these excuses parallel problems that had occurred long before. So to me, it was not surprising.
Ms. Gray?
Yes.
Ms. Gray, wait just a moment.
Ms. Gray, on June 1st, and I'm looking at page 400 of the record, for anybody who's playing along, I suppose, you indicated to the court that you agreed with the mother with respect to her motion to dismiss the petitions. You said, I agree with Ms. Perrin, has not been given enough time to comply with the suspended judgment since the first violation petition was filed approximately a month after the suspended judgment. And so it seemed that you favored the mother, and you were supportive of the fact that she just didn't have enough time. She had been making progress, and this wasn't the kind of severe case that you might see, especially this quickly after the order. And then I noticed 2 days later, on June 3rd, it seemed that your position changed dramatically. I'm looking at now 595 of the record, that you then substituted your judgment and said, even though the children wanted to live with the mother, that you're in favor of DSS and the termination. What happened in the 2 days?
I don't recall, Your Honor, that anything specific happened within the 2 days. At that point, we were trying very heartily to settle the case. And the hope was that there could be maybe an additional couple of months to see if the mother could comply. The response to those settlement negotiations, and I also spoke with my clients as well, that although they were saying that they wanted to go back to their mother upon further discussion with them and discussion with their counselors, I believed it was not in their best interests.
Thank you.
Right now, they are Zachary's almost 9, Daniel is 6. They've been living with the same foster parents for well over 4 years, doing well in school. They're engaged in clubs. And I spoke with Zachary and Daniel last night, and they're both very eager to be adopted by their foster parents. The mother has made no contact with them. She is, my understanding from the caseworker is that she is now living with a new boyfriend and expecting another child.
Thank you very much. 26, in the matter of Adrian Kirkland versus Tangeline Crawford. Go ahead.
Good morning and welcome, Justice Keene. Fabian Santacroce for Ms. Crawford. I have to admit at the start here that the reconstruction hearing was a valiant effort. I have no issues with the procedures used by the court below, but I still believe it was inadequate to protect Ms. Crawford's right to appeal, and that's mostly due to the sheer amount of testimony that had to be reconstructed. This was over 45 minutes of testimony. It was almost the entire cross-examination of a key witness, the father, by my client's trial attorney.
But my understanding is from the record is that there was no objection to the manner in which this reconstruction was undertaken, either before, during, or after.
So I did move for the reconstruction hearing based on case law, and Wagner versus Wagner then came out, which discusses, that you should try, if you can. I think the exact language is, if possible, you should try.
They did try.
They did try, and
based on the notes that the hearing officer took, some are better than others. You couldn't go off my notes, but I know some of my colleagues you could.
and that's why I admitted that right from the start. But I did put in my brief, and I can go into that the attorney referee had said some things prior to this testimony that already showed where she was leaning.
Well, I don't know that I've seen that in the record, but I did see that there was a proposed resolution to the missing transcript that was agreed by everybody. Then it was done, and then nobody objected.
So no objection was made at the reconstruction hearing because the procedure, there's no issue with the procedure. I thought they did a fine job. My argument is still, though, that's not enough. There's too much missing testimony. And there are other things that are in my brief, but mostly it comes down to the sheer amount of testimony and it being from a key witness. This wasn't like we lost a closing.
That. Okay.
Thank you.
We'll look into that. Thank you.
May it please the court, counsel Timothy Davis for Mr. Kirkland. I'll just address the reconstruction hearing. At this point, it appears that the argument is that it was insufficient because of the reconstruction was insufficient because it relied on the notes of the referee. Quite frankly, this is not a jury trial where the referee would be doing, it would then be a judge doing other things, paying attention to questions, ruling on objections, and ensuring the jury did not hear anything prejudicial. This is a case where it was a referee who knew that she had to prepare a decision right after that. There's no way to say that because the amount of testimony took 45 minutes to 50 minutes, that all of a sudden that meant that the court's notes were insufficient.
There was no objection to any of this, correct?
No, there wasn't.
So it's not really a preserved issue for us, is it?
No, I was simply responding. But,
why don't you talk about the merits?
Yes, this is a case where, unfortunately, there is a child who, in one living circumstance with the mother, was not put first by that parent, and with regard to the father, it appears everything the father had done was to help this child.
Wasn't there a significant period of absence of the mother? To an extended trip to Texas or something of that nature?
There was. The record isn't clear, but apparently the mother and father agreed that the child would remain with the father. I believe it was in May or June. School was going on, and there was talk about needing to stay with the father to get in physical shape, I think was one of the things that was testified to, as well as help him with school. The father did not know that the plan was for the mother and the middle child to go to Texas. Quite frankly, that testimony was dizzying. The mother testified that she went down there to...
We understand all that, and then the son said, no, that never happened. Okay, we understand all that.
Okay, thank you.
May it please the court, Maureen Poland from the Legal Aid Society of Buffalo for the Child, or of Buffalo, excuse me, of Rochester. I don't know. Sorry. I'm not sure where that came from. So I just wanted to briefly update the court on how my client is doing. I think the court knows the arguments on all sides. My client was 9 when this case started. He is currently 12. He still resides primarily with his father. I just went out to see him at his father's home last week. He's doing well. That's still where he wants to be. He got to play football this past year, which I know is something that was brought up in the record frequently. So he isn't looking for any changes, and certainly I'm not looking for any changes either. So I addressed on my papers unless there's any questions.
Thank you.
Thank you.
And when you leave, remember you are in Rochester.
I know.
So, okay.
Thank you.
27, Blackman Loan Services versus Timothy Maffett. I'm waiting for Mr. Gordon, am I right? Is Mr. Spatorico here? No? Looks like you're solo, Mr. Gordon.
Thank you, Your Honor. Good morning, Your Honors, and congratulations, Judge Keene. If you support, my name is Matt Kemp, I represent the this appeal asks the court to consider the very simple question of whether the trial court exceeded its jurisdiction authority to granted order of show cause brought by defendant respondents. We argue and vacate the trial court's prior order, which had granted plaintiff appellant summary judgment in the underlying foreclosure action. I submit that the trial court's order granting respondents order of cause should be reversed.
Wait, I'm sorry, we're having trouble hearing you. So, first of all, why don't you try to sit still? I think that might help, okay? Try again.
Can you hear me now?
Yes.
So I submit that the trial court's order granting respondents order to show cause should be reversed, as the trial court lacked jurisdiction to hear the order to show cause, did insufficient service, and lacked statutory authority to reconsider the order under CPLR 2221D or vacate the order under CPLR 5015A1.
Counselor, can I interrupt you for a moment, please?
Yeah.
Can you hear me all right?
Yes.
Okay. So the order to show cause directed that the service be completed by overnight, no later than the 6th of June, correct? Yes. And on that day, your office contacted the court via NICEF and requested that this matter be heard virtually. Is that right?
Yes.
All right. And so your contention here is that you should have received hard copy papers of a matter that you wanted to be heard virtually.
Correct.
So is that a meaningful request that you want the proceeding to appear virtually, but yet you still need hard copy papers?
Well, Your Honor, there's a case law that says that the matter of service directed in order to show cause is jurisdictional. So it's not about notice necessarily, but it's whether or not the trial court was able to obtain jurisdiction to even consider the motion.
Well, I understand that argument, but your letter to the court said you received the papers, and there seems to be some question in the record. I know there isn't an affidavit of service, but some question in the records whether the papers were actually received in your firm's office or not. But you did at least have digital copies of the papers.
Right, they were served via NICEF, yes.
Right.
Okay, thank you. Do you have anything further?
Well, I wanted to say that the trial court also exceeded its authority, its statutory authority to consider when it considered the motion. Motion to re-argue was brought untimely. It was brought almost, I believe, 3 months after the statutory deadline expired. The respondents also brought their motion under CPL 5015A1, unreasonable reasonable default, but they didn't default in opposing the summary judgment motion. The record has their opposition to the summary judgment motion, so vacating under the statute is improper. And further, I would just add that the court was included by the law of the peace doctrine under Brady Cox due to a prior appeal that the respondents had brought of the summary judgment order that was then dismissed for failure to prosecute. Brady Cox held that a dismissal for failure to prosecute would be on the merits of all claims which could have been litigated in that appeal. So that became binding on the trial court, which was then didn't have the authority to reconsider the issues which could have been raised in summary judgment.
But I'm so sorry, if we revisit if we find that the court could revisit the standing issue, because it's just an interlocutory ruling during the proceeding and the court decides to revisit the standing issue, are you disputing that you had notice of the standing issue based on the order to show cause? I know that wasn't the relief sought, but they sought other further and different relief. And it would seem that would have sort of passed it on to you then to demonstrate standing that Aquin had the note.
Let me make sure that I'm understanding your question correctly, Your Honor. Are you asking if the fact that the respondent ordered to show cause to re-argue was served gave us notice of the issue?
Whether the motion papers gave you notice that the standing issue was going to be revisited, which would then trigger you to say, oh, no, we did have standing, and demonstrate that, which I think is what the judge is having an issue with.
Sure. I mean, it gave notice, but our position is that it shouldn't have been reconsidered. It wasn't subject to reconsideration due to lack of statutory authority and the law of the doctrine.
Right.
Notice of it, but it wasn't subject to revision.
Okay.
Thank you.
Thank you, Your Honor.
28, Stanton versus Waterfront Center for Rehab. And you are solo today, Mr. Hogan.
Thank you, Your Honors. Good morning. As a respondent, there's just two things I wanted to briefly mention, and that is that the factual record is undisputed. We've got the Department of Health investigation in the record. None of those facts were disputed in the lower court or on the initial brief that was filed here, which this, of course, includes the fact that the nursing home knew as of October 28th that Mrs. Keller, who had recently undergone eye surgery, had an infection in her eye.
We know all the facts.
You know all the facts, right. And the only other thing I would mention then is that on causation, the expert affidavit just didn't address the central contention, which was that the delay in treatment caused the infection to spread to the point where she had to have her eye surgically removed. That's all I have.
Thank you.
Thank you.
29, Upstate University Hospital versus Bryant W. And we have to wait for Mr. Chamberlain. Hello, Mr. Chamberlain. You're solo today.
Good morning, Your Honors. May it please the court. I do understand that I'm appearing unopposed, I guess, today. The opposing side has submitted, but I did want to be heard briefly because this is a particularly unique case. Our position is that it was error for Supreme Court to extend an expired treatment over objection order and allow that to be transferred from a medical hospital to a county jail facility. There was no valid order for the court to transfer in the first place.
Isn't this moot at this point?
I don't believe it is, Your Honor. I think, first of all, getting to the mootness point, the state does not oppose the idea either that it's a substantial and novel issue or that it's an issue that can evade review. So the only one of the three prongs of the mootness exception that it's in dispute here is whether this is an issue that can recur. We submit that it's not inconceivable that other hospitals may attempt to do this in future cases, extend otherwise expired treatment over objection orders and ask that they be transferred to county facilities. Essentially what happened here is...
Again, we know all the facts.
Yeah, I just want to characterize them in a certain way to paint a picture here, and that's that Upstate knew this order was going to be no longer valid when they discharged Mr. Williams. That was documented in the record at page 76. The county sheriff failed to act to bring a treatment over objection petition so that they could continue to medicate Mr. Williams in the county jail. Rather than just saying, well, the county failed to do so, there's no relief here, Supreme Court, for some reason, felt the need to sort of swoop in and save the county from their own error. Upstate said, well, the county didn't act quickly enough. Well, frankly, that means the order no longer is valid. So, the fact that there may have been some concerns by Supreme Court with respect to Mr. Williams' level of violence and the need for continued medication, there are procedures that need to be followed. The county failed to do so timely. With respect to the mootness issue you raised, Justice Smith, we did point the court to Alexis H., which is a case where this court did find the exception to the mootness doctrine to apply in a novel treatment over objection context where there was a new interpretation of law. Essentially, the state concedes that this is not something that has ever occurred before, and we agree. It's completely unheard of for a medical hospital to ask for an expired order for a patient they already discharged to transfer to a county jail facility. And I think the state's reliance on the recent Jason L. decision from this court is misplaced for a couple of reasons. The reason this court found that case to be moot was because it was a weight of the evidence challenge, and the court said it's speculative the exact same factual circumstances will be raised again. This is not a weight of the evidence challenge. This is a purely legal question about whether this order could be transferred. I don't believe it's moot because of that, Your Honor. Just to wrap up, this was a clearly expired order. It had expired by its own terms. Upstate was not in a position to bring a petition. He was no longer their patient, and that's the case. He no longer met the definition of a patient under the Family Health Care Decisions Act. So for those reasons, there was no valid basis for Upstate to ask for this to be continued, and no valid basis for which the county jail could assume control of this order. So we believe the Supreme Court committed error for all those reasons.
Thank you.
Thank you.
31, David Abatoy Jr. versus Todd Baxter.
Morning, Your Honors. David Abatoy.
Representing yourself.
I'm appearing pro se, hoping not to run afoul of any wise sayings about self-representation.
I was going to say it, but then I decided.
Thank you, Judge. I appreciate it. The core issue before the court on this application really relates to the doctrine of retroactivity, but I really think there is a...
Let me ask you this question. Forget about what you did in the past. If you today asked for these same documents, wouldn't you be entitled to them?
I would, but I think I would be denied, or I would only have access to them starting in 2020 when the...
what they accumulated from 2020 onward.
Right. The petition or the request that we actually filed sought records going back through, I think 2001 it was. And that is the time period in question here. That's the time period that the lower court decided. I think the question before the court is sort of a narrow one with respect to the retroactivity doctrine, and that is, what should a court do if the legislature does not specifically address retroactivity with respect to a FOIL request? The case law on this subject, and I'll just cite one case, I think they're unanimous, the Farbman case that I cite in my brief from the Court of Appeals, says that it is the agency's duty to, quote, clearly, to show, quote, clear legislative intent to establish and preserve confidentiality. I think the analysis in the lower court, and on behalf of and that my opponent attempts this court to adopt, sort of turns that on its head and tries to put it back in our lap to demonstrate the legislature's intent to treat it retroactive, or intent to impose retroactivity. But that's the opposite of the analysis this court should engage in. This court should put the onus on them to demonstrate that there was a clear legislative intent to preserve confidentiality. And the things that are in the record before you, and just the things that I think are public knowledge with respect to the adoption of this 2020 repeal, clearly shows that the legislature wanted something to happen immediately because they viewed this as a public problem.
Okay, we'll look at that very
And
carefully.
that's what if I could, Judge, I just want to point out a couple wrinkles, I think, with respect to how this occurred. That first off, the NYP Holdings case says that specifically. This was meant to be remedial. The legislative intent of FOIL in general is to have, quote, maximum access to records. If you adopt my opponent's position, what you'd be concluding is that on the day that this statute was passed, 0 records would be available to the public because nothing that previously existed would be available at that point, and we'd just have to wait for things to accrue along the line. That's not maximum access. We have shown, Judge, if I could just go on to additional argument, if you do conclude that there is some onus on us to demonstrate a legislative intent, the record does show that. The governor signed this saying, this is page 141 of the record, that he expected prior disciplinary records to be revealed. And the legislature, in adopting this, sort of bemoans the policy that came out of their previous actions and indicates an attempt to correct that. And if I could just
We'll look at all that, Mr. Apatow.
if I just have one final point, Judge, I'm sorry. Finally, I'd ask the court to reject what I think is kind of the core of my opponent's argument here, which is that certain waivers with respect to these disciplinary proceedings were entered into, they say, because of this confidentiality provision. I think this court should reject that conclusion absolutely. They didn't enter into those waivers to gain confidentiality. They would have had that confidentiality whether they waived or not waived. That was a statutory protection. So there's no bargain for
Is
exchange.
it the
there.
idea they would have written something different in the disciplinary records had they know they were going to be exposed to the public? Is that the idea?
I'm not truly making that argument, Judge. I think it just,
Oh, no, you wouldn't. They might. Is that their argument to some extent?
I think what they're trying to do is latch onto this idea that there was some, to adopt a phrase, like detrimental reliance on the existence of some thing that occurred by way of contract that they believe is enforceable with the sheriff. And my point is that there really wasn't any bargain for exchange there, nothing like we think of as a contract, because they didn't gain that as a result of an exchange. That they would have had that whether they bargained for it or not.
Because it was in the law.
Just existed by concept. Now that statute is gone, they can't rely on it anymore.
Okay, I think we have that.
Thank you, Judge.
Good morning, Your Honors, and welcome, Justice King. I think to address the last thing first, as far as the bargained for issue, the discipline that we're talking about, the choice was between something that was confidential and protected by the law, as he said, or between a public hearing, which could have been attended by anyone in the public, and the record would have been available to the public. So there was, I don't know that it was bargained for, but there was a choice between something that's going to be public and something that's going to be confidential, and it wasn't necessarily bargained for because we were in that statutory environment where it didn't need to be put into a contract because the statute provided for it. To go back to the beginning, I think the main point is that the case law here, including this case, this court's recent decision in the Ruth versus Elderwood case, and Section 93 of the General Construction Law are very clear that when a law is repealed, if it's going to be retroactive, it has to be clearly stated to be retroactive by the legislature. And the legislature did not clearly make this law, this repeal, retroactive. And that's sort of shown by the fact that they easily could have made a law that was retroactive because they've attempted to do that now, and that didn't pass. And I think the importance of that is that we don't know if that law that was retroactive had been put before the legislature. We don't know that that would have passed, and we don't know that the government would have signed that. So unless there's any other questions, I think.
Thank you.
Okay, thank you.
32, Harry Hall versus God's House of Refuge.
Good morning. As a fellow Eagle, I'm happy for you, Judge Keene. Tim Bellavia for the plaintiff appellant in this case. And with respect to the appeal that relates to the memorandum of law being included as the part of the record, I'll rest on my papers with respect to that and the arguments contained therein. Our argument here is the Judge below granted sua sponte relief. In other words, the defendants, not only in their notice of motion, not only in defense counsel's attorney affirmation, and not only in the affidavit of their expert, did they say repeatedly, we're seeking three specific forms of relief. One is we're going to compel the plaintiff to appear for the defense medical exam. Two is we're going to compel, hopefully get a protective order, barring the video or audio taping of the exam. And then three is barring the production of raw data to plaintiff's counsel. Those were the three specific areas of relief that were requested in the notice of motion, defense counsel's affirmation, and the affidavit of the expert. The judge then grants...
The affidavit of the expert, 5 pages, and I would submit to you 4 3/4 of those 5 pages are talking about third parties. But that's really, that's everything that the expert's focusing on. Dr. Fisher's affidavit, 93 to 97. How's there not notice that that's an issue that can be ripe?
How I read Dr. Fisher's affidavit, Judge, was that he focused also on the audio and videotaping and the part about keeping any third party from attending. When I read the notice of motion under 2214A, and when I read the affidavit or affirmation of Dr. Fisher, the affidavit of Dr. Fisher and the affirmation of defense counsel, my thought on that is, wait a minute, they're not seeking that specific relief. And the only thing I saw in their memorandum of law that why they wanted that included in there was a blurb from Dr. Fisher, not 4 pages of his affidavit, but a blurb there saying, one paragraph specifically saying, apparently, that no third party should attend. My experience...
The recording is 1 paragraph. It's one little paragraph throwaway, and I might agree with you that paragraph about recording is conclusory. Because all it says is, normally, that's not done, et cetera. But that's not preserved. That's not appealed. So we're not. That's been abandoned. That argument. So all we're dealing with is whether or not there should have been a response to third parties. Was there any effort to ask the court, perhaps at oral argument? I think it may have been submitted, but why wasn't there a request of the court saying, gee, are you considering this? In which case you could have asked for a couple of weeks to submit something.
I think for me, Judge, it was 2214A says if you're looking for specific relief, it needs to be in the notice of motion. And then not only was the 2214A relief that they put in their notice of motion, it was repeated again in defense counsel's affirmation. Specifically, these are the 3 specific points we're looking for, Judge. These are the 3 specific areas of relief. And then Dr. Fisher's affidavit, again he states in paragraph, I believe it's paragraph 2 of his affirmation on page 93 of the record. And in defense counsel's affirmation, it's paragraph 2 on page 10. They repeat the 3 specific forms of relief they're seeking from the court. If it was my job in responding to the motion to sift through defense counsel's papers or my opposition's papers and determine, well, what other forms of relief could they possibly be seeking here? The other issue I had is, in terms of Dr. Fisher's affidavit, Dr. Fisher's been doing this for a long time. I've sat through defense IMEs conducted by Dr. Fisher with no objection by Dr. Fisher in the past. It didn't appear to me that that was the relief being sought. And it didn't appear to me they were asking the court to grant that specific relief. The other problem is there's completely different legal standards. If I'm looking to bar somebody from videotaping, well, this department has said repeatedly, you got to show special and unusual circumstances. Well, I have a blind and cognitively impaired client. And the standard for excluding someone from attending a defense medical exam with their client, this court has said it's as important as attending and representing your client at a deposition as it is to attend a defense IME, because it's not an impartial examiner. He's hired or she's hired by the defendant, and that's the Jakubowski case. So the 2 different standards for the 2 different forms of relief, Flores talks about videotaping and audio taping, very different from banning a counsel from appearing with his client at at a defense medical exam, and that's the Jakubowski case. Again, these were 3 specific forms of relief repeatedly asked for, and when the judge granted a 4th form of relief, not asked for in the notice of motion, not asked for in the defense counsel's affirmation where he lists what he's seeking, and not asked for by Dr. Fisher, in his second paragraph of his affirmation of what he's specifically seeking for relief. Given their different standards, it's not within the judge's discretion to award something as, oh, they also requested such other and further relief as the court deems proper. This is substantially different, as this court talks about. The legal standards are very different, and we should have had an opportunity to brief and talk about those standards in terms of banning someone from attending a defense medical exam with their client versus video or audio taping.
Okay.
There's all, oh, sorry,
So
Judge.
I'm just confused because I have your brief right here, and it's not the first time I'm looking at it, okay? And there's one argument and one argument only, okay, which talks about attending the defense medical exam, okay? It doesn't talk about the videotaping, which, might be some sort of a substitute for an in-person buddy.
The appeal based on the case law was focused on the lower court's decision to ban specifically.
Well, what do we do with their decision to ban videotaping or audio taping or something that can at least allow there to be some kind of scrutiny?
That part of it, based on the case law that I was reading, I did not appeal. I appealed specifically the issue of, there are alternative methods, I think, of doing such things, but my review of the case law on that, I focused on the sua sponte decision to ban a third party from attending with the plaintiff. That's where my focus
So
was.
I'm not missing the fact that you didn't appeal that part?
No, that part was not. I feel specifically was having a third party attend the deposition, because that, in my opinion, was sua sponte relief, and it was substantially different. The other,
Counsel, you made reference to the provision about, it's got to be in the notice of motion. This wasn't in the notice of motion, the thing about the third parties. I appreciate the argument. The problem I see is CPLR 3103A, and this is in the defendant's brief. The court may at any time, on its own initiative, make a protective order denying, limiting, conditioning, et cetera, the use of a disclosure device. What do we do with that? It's on its own initiative, and you say, well, the court can't do it on its own initiative. Aren't you asking us to say 3103A is null and void?
well, I think, I think it goes back to sua sponte relief and kind of judge issue an order without really being heard, without allowing a party to be heard on an issue.
Well,
And in this case, and in this case, I think that's what happened. When you ask for 3 specific forms of relief multiple times in your notice of motion, as 2214 requires, in your affidavit of your defense counsel, in the affidavit of your expert, 3 separate entities saying this is the specific relief we're asking for, and we don't get a chance in front of the judge to talk about that particular relief that the judge awarded, and that particular relief is substantially different, as this court talks about, the legal standards that this court has set for video audio taping versus barring a plaintiff from having his counsel with him during an IME is substantially different.
Why do you say you didn't have the opportunity?
I'm sorry?
Why do you say you didn't have the opportunity?
Because it wasn't brought up even at we had no idea the judge was going to consider it, because I'm relying on the notice of motion, the specific forms of relief they're asked for. I didn't brief. It's a lot to ask, and I think, Judge, I cited the Abizadeh case in my reply brief, and it says that if you're going to require a party to have to sift through and identify issues that might come up that aren't specifically asked for, in the notice of motion as 2214 requires, and then beyond that, beyond 2214, they specifically stated in the defense counsel's affirmation and the expert's affidavit, this is the relief we're looking for, Judge, nothing more. There's nothing else that
Okay, I think you made that very clear.
Thank you. Thank you,
Thank
Your Honor.
Good morning. May it please the court. Matthew Lenhart for the defendant. I think it's interesting, I know the plaintiff doesn't have to argue both of the appeals, but I think it's interesting that he chose not to, and that's because the one part of the underlying appeal is that the relief sought was granted sua sponte. The second appeal was all about keeping out our memorandum of law, in which we specifically requested that relief. I believe it is completely proper for the court to have considered that relief. That was in the memorandum of law. The court considered the memorandum of law. It should have been part of the record of appeal. It now is part of the record on appeal, and the court should certainly rely upon it. So just when it comes down to the merit of the underlying appeal, grasping on Judge Nowak's comments, this was not hidden in the motion anywhere. There were fully 4 pages of the expert affidavit discussing this issue at length. It was in our memorandum of law. And what I think is most important is that it is completely unrebutted. So we have offered in support of our motion to meet our burden of proof and moving.
You wouldn't disagree it was completely unaddressed by the plaintiff. It's as if the plaintiff read the motion and said, well, the motion doesn't seek that relief, so I'm not going to address it. That was really what the record reflects, right? There was some reliance on the notice of motion because it's not even mentioned in the plaintiff's opposition below.
I would agree that they did not mention it in their papers. But certainly, Your Honor, it's in the expert affidavit. And as you were saying, I was thinking of the number of layers of why the courts...
Your expert affidavit. They didn't even put in an expert affidavit.
And they should have. That's how you defeat this, because I'm not a neuropsychologist, the court's not a neuropsychologist, my opposing counsel's not a neuropsychologist. So what you rely upon is his affidavit, which says the results of my test will be skewed if there is somebody in the room, or even if videotaping. For a number of psychological reasons, he devoted 4 pages in the papers to it. So the way the plaintiff would have had to have opposed that is to offer an expert affidavit, and they chose not to. So they keep saying that they didn't have an opportunity to do these things.
And you're just saying they didn't take the opportunity.
Absolutely, Your Honor. We are charged with reading the papers that we are served with. I was also thinking...
Why shouldn't we read Dr. Fisher's affidavit as saying that he makes a prima facie case, you can't have supportive people. Can't have the attorney, can't have the wife, can't have people nudging and whispering and saying, hey, answer the question this way. Because the affidavit clearly says that. He devotes a paragraph to supportive people. Is the affidavit clear that people that are completely neutral, have nothing to do, a complete stranger just there to observe, that would interfere?
He offers a number of reasons. I have paragraph 15 flagged in my notes, and it talks about in the mere presence of this person, not even directing answers and so forth, but the mere presence can skew the results because they're anticipating what that person's reaction might be.
Is that the paragraph that talks about the one-way mirror, or is one-way mirror 16?
15 is one-way mirror.
Okay, so one-way mirror. So what he's saying is essentially the problem with having another person, a third person in the room, is that the plaintiff knows. The plaintiff knows it's being recorded. The plaintiff knows a person's there behind the mirror, and that's the problem because that skews the results.
Exactly.
We have a legally blind plaintiff here. How would they know? How would he know?
He wouldn't know if it's a one-way mirror either if he's blind. How he knows is that his counsel tells him that I'm going to be there with you.
So why isn't the appropriate result for the court to say, I'm going to order that the plaintiff's counsel doesn't tell him that somebody's watching? According to Dr. Fisher, why wouldn't that be sufficient?
Well, Your Honor, I don't think Dr. Fisher addressed that possibility. I don't know how you enforce that or trust that, first of all. Second of all, again, I rely upon Dr. Fisher as the court should rely upon Dr. Fisher. He has laid out why there are these problems. Now we're trying to craft some relief to get around that, which relies upon unforeseen things, privileged communications between the plaintiff's attorney and his counsel. And don't forget that this talk about the plaintiff being blind and so forth, it doesn't prevent him from going to his own doctors alone, right? So that there's no prejudice to the plaintiff by having him go forward with this. I think I will largely rely upon my papers for the other arguments. I think we have not only belts and suspenders, but another belt perhaps too upon this being in our papers, so the plaintiff had notice of the argument or should have had notice of the argument, it being within the court's discretion to grant substantially similar relief, and furthermore, simply that the merits of the case as established by Dr. Fisher are unrebutted. And it was the plaintiff's obligation to offer those circumstances that require this additional step.
Thank you.
Thank you.
34, Kramer versus Glaper. You have to wait just one moment for Mr. Del Palma. Good morning. Okay, go ahead.
Good morning. May it please the court. My name is Justin Huffman, and I represent the plaintiff appellant in this action, Robert Kramer. There is only one single issue in this appeal, and that is whether the lower court properly granted defendant's motion to dismiss the portions of this action sounding in tort based upon the statute of limitations. Now, the complaint, as well as the proposed first amended complaint here, sufficiently allege a series of events giving rise to the continuing harm doctrine. Specifically, the defendants were continuously tied into the septic tank located on plaintiff's property since approximately 2014, which has often resulted in sewage material seeping onto plaintiff's property, damaging the property and causing a foul odor on the property.
So it's your position that this is a continuing trespass and it evades the statute of limitations entirely?
That is correct, Your Honor.
Okay, that's what I got from your brief.
And the lower court, unfortunately, did not provide any meaningful analysis of either the continuing harm doctrine or even when the lower court deemed the torts to have occurred. Here, the complaint and proposed amended complaint sufficiently allege the defendant's installation and continued use of the septic tank on...
It's been uninterrupted since it was put in maybe 12 years ago.
Correct. And the defendants made reference to a pipe and clean out that was done in 2016, claiming that this somehow eliminated the possibility of damage to the property. And that's simply not the case, and defendants allege evidence to that end.
We're not concerned with that. You know, we're concerned with your issue, the statute of limitations and whether this is a continuing tort.
And that's correct, Your Honor.
So you've laid that out. Do you have anything further?
What's that? Sorry, Your Honor?
I said, and you've laid that out. Do you have anything further?
Only I think it's notable that the lower court pointed out that the defendant's purported evidence here was insufficient to meet the summary judgment standard and that this was the motion to dismiss phase. And I think it's key to note that the plaintiff here properly pled the causative of action here.
Thank you. Mr. De Palma?
We can't hear you.
You have to unmute yourself. Wait.
Sorry about that.
There you
Now,
go. Yes,
All right,
thank you.
The septic system has been installed since before my client ever took possession. It was installed by the prior owner of the property who owned both the 1701 and 1705 parcels. And in about 2005, the leach lines were disconnected and capped off, so none of the actual sewage would drain onto the Kramer property.
I'm sorry, we can't hear you. Excuse me, we can't.
Can you hear me now?
Barely. Can you get a little closer to the microphone?
Is that better?
Yes, thank you.
Subsequently, Your Honor, there was the capping of the lines and the fact that no longer was any discharge effluent going onto the property. And they did the removal of the sewage.
Wait, once again, we can't hear you. Can you sit still and get closer to the microphone, please?
How's this, Your Honor? Is that better? Is that better, Your Honor?
Barely. Can all of you hear?
Yeah, it's very muffled.
Yeah, you're muffled, so try to speak clearly, please.
Okay, Your Honor, I'm trying the best I can. Can you hear me now?
Oh, that's good.
That's good. Okay. So, in 2000, when the capping was done, the only thing that would happen is a small amount when the tank was empty may have discharged onto his property. However, in 2016, this was totally eliminated by the fact that the piping was now extended over onto my client's property, where the tank could then be cleaned and the discharge all would be on his property. This was in 2016. So in 2021, when this case was brought, it'd been approximately 5 years since that had occurred. So during that time frame, in 5-year period, there's been no mention or any reference of any days, dates, or direct correlation to any of these events that are alleged by the plaintiffs. And again, so that would be a fact that the case is timed out and time barred, and the lower court absolutely saw this, and that there is no continuing wrong doctrine that applies in this case.
Thank you very much.